Hello everyone. Today I'd like to give you a quick overview of how China's new company law, which took effect last year, has specified the legal responsibilities of company directors, supervisors, and senior managers. These roles are often referred to as D&O, directors and officers. The key focus here is on two duties, loyalty and diligence.
1. Who are regulated by the provisions of duties.
These provisions of duties apply to not only official directors and managers, but also people who act like them, even if they are not formally appointed. The law now covers so-called de facto directors and shadow directors. A de facto director is someone who makes decisions and acts like a board member without a title. A shadow director is someone who gives instructions behind the scenes. For example, a controlling shareholder telling the board what to do. If that causes harm to the company, both the shadow director and the official director can be jointly liable.
2. What do these duties mean in practice?
Let's break it down. Duty of loyalty means you have to put the company's interests above your own. No self-dealing, no secret profits, no transactions that benefit your spouse or your side business unless fully disclosed and approved. Duty of diligence means you need to act responsibly, make informed decisions, and take your role seriously, whether it is running a company, making sure capital is in place, or handling liquidation procedures as needed.
3. What happens if you break the rules?
When these duties are breached, directors and executives may face civil liability. They may have to return any profits made from the self-dealing or compensate the company for losses. Let me give you a real example here. A company's general manager signed a renovation contract with a business secretly owned by his wife. The renovation ended up costing far more than it should have, and the actual money flowed into their personal accounts. The court ruled that the manager violated his duty of loyalty. But it does not stop there. Starting March 1st, 2024, Chinese new criminal law amendment extended the criminal liability for loyalty breaches. Previously, criminal penalties like illegal self-dealing or abusing company resources were limited to directors in state-owned enterprises. Now the same rules apply to private companies as well. That means whether you work in a public company or a private startup, violating your duty of loyalty could land you in criminal court, not just civil. On the diligence side, if a director or supervisor neglects their role, such as failing to monitor how company funds are used, and that leads to the financial loss or harm to creditors, they could also face personal liability. And yes, this also includes the so-called dummy director. That means the people who hold the title but don't actually do the job. If you wear the title, you wear the responsibility.
4. So what shall companies do?
First, tighten internal controls and clearly define roles in your articles of association. Second, use compliance audits and board procedures to catch conflicts early. Third, buy directors and officers insurance to reduce the financial risk of honest mistakes. Buying such insurance is now firmly encouraged by law.
5. For directors and officers, here's what matters.
First, check if shareholders actually paid their capital, and follow up if they didn't. If you ignore it and losses occur, you might be on the hook. Second, always act in the company's best interest. Make smart legal decisions. Third, avoid conflict of interest. Be open about your times and stay clear of shady deals. And last, if you are just a figurehead, you should resign from the company. Name-only rules do not protect you from any risks. In short, the days of sitting back and signing off without thinking are already over. Directors and managers are expected to be active, informed, and accountable, not just on paper, but in practice. And that is also a big step forward for corporate governance in China. Thank you all for listening.
Your reliable lawyer in China.